Welcome back to the channel for the video lecture series on company law. In today's lecture, I am going to finish off the first unit of the company law syllabus, which consists of promoters, their duties and liabilities. And after this, I am going to start with the second unit of the company law from the next lecture, which would cover the incorporation of a company. So let's keep that topic for the next lectures and start with today's topic, that is promoter of a company. When an individual has an idea for a new business venture, he or she may set about interesting others in the venture and persuade them to contribute capital to a company to be incorporated for the purpose of carrying on the venture. The individual will then be described as promoter of the company. A person who acts in a professional capacity is not a promoter. A company is born only when it is duly incorporated. For incorporating a company, various documents are to be prepared and other formalities are to be complied with. All this work is done by promoters. Then the question arises that who really are promoters of a company? The most important work of a promoter is in the formation of a company. The whole process of the formation of a company may be divided into four stages. First, promotion. Second, registration. Third, flotation. And fourth, commencement of business. Promotion is a term of wide import denoting the preliminary steps taken for the purpose of registration and flotation of the company. A promoter may be an individual, syndicate, association, partner, or company. The expression promoter has been defined under Section 2, Clause 16 of the Companies Act 2013, which states as promoter means a person who has been named as such in a prospectus or is identified by the company in the annual return referred to in Section 92, or who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise, or in accordance with whose advice, directions, or instructions the board of directors of the company is accustomed to act, provided that nothing in the subclause 3 shall apply to a person who is acting merely in a professional capacity. The term is used expressly in sections 35, 39, 300 and 317. In the case of Boscher versus Richmond Land and Company, the term producer or promoter has been defined as a promoter is a person who brings about the incorporation and organization of a corporation. He brings together the persons who become interested in the enterprise, aids in procuring subscription, and sets in motion the machinery which leads to the formation itself. A promoter is one who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose. L.J. Brown, in the case of Whaley Bridge Printing Company, observed that the term promoter is a term not of law but of business. To be a promoter, one need not necessarily be associated with the initial formation of the company. One who subsequently helps to arrange floating of its capital will equally be regarded as a promoter. However, a person assisting the promoters by acting in a professional capacity do not thereby become promoters themselves. The relationship between a promoter and the company that he has floated must be deemed to be fiduciary relationship from the day the work of floating the company starts and continues up to the time that the directors take into their hands what remains to be done in the way of forming the company. The status of the promoter is generally terminated when the board of directors has been formed and they start governing the company. Chronologically, the first persons who control or influence the company's affairs are its promoters. It is they who conceive the idea of forming the company, and it is they who take the necessary steps to incorporate it, to provide it with share and loan capital, etc. When these things have been done, they hand over the control of the company to its directors, who are often themselves under a different name. On handing over the control of the company, the promoter's fiduciary and common law duties cease. and he is thereafter subject to no more extensive duties in dealing with the company than a third person who is unconnected with it. Now let's talk about meaning of promoter. A promoter is a generic term associated with the person who starts a business. In common parlance, this person is also referred to as the founder of the business. A promoter typically is responsible for raising capital, targeting initial leads, and chasing initial business opportunities, entering into the initial contracts for the business formation, and incorporating the company. The substantial acquisition of shares takeover regulation states that the promoter is first any person who is in control of the target company, second any person named as promoter in any offer document of the target company or any shareholding pattern filed by the target company with the stock exchanges pursuant to the listing agreement, whichever is later. In the old Companies Act 1956, there was no static definition of promoter, although it was mentioned in various sections. But in the new Companies Act 2013, Section 2 Clause 69 defines promoter clearly. Now let's talk about position of promoter in Companies Act 1956 and in different statutes. The term promoter has not been defined under Companies Act 1956, although the term is used expressly in sections 62, 69, 76, 478 and 519. Section 62 of Companies Act 1956 defines promoter for the limited purpose of that section only. Section 62 Clause 6 Subclause A defines the expression promoter to mean a promoter who was a party to the preparation of the prospectus or of a portion thereof containing the untrue statement, but does not include any person by reason of his acting in a professional capacity in procuring the formation of the company. In Twycross vs. Grant, promoter was described as one who undertakes to form a company with reference to a given project and to set it going, and who takes the necessary steps to accomplish that purpose. In USA, the Securities Exchange Commission Rule 405 Subclause A defines promoter as a person who, acting alone or in conjunction with other persons directly or indirectly, takes the initiative in founding or organizing the business enterprise. In Laguna's Nitrate Company Limited vs. Laguna Syndicate, it was stated that to be a promoter, one need not necessarily be associated with the initial formation of the company. One who subsequently helps to arrange floating of its capital will equally be regarded as a promoter. The difficulties in defining the term led the judges to state that the term promoter is not a term of art nor a term of law but of business. Now let's talk about position of promoters in Companies Act 2013. The new Companies Act has defined promoter in section 2 clause 69. A person who acts in a professional capacity is not a promoter. Thus, a solicitor who prepares on behalf of the promoters the primary documents of the proposed company is not a promoter. Similarly, an accountant or a valuer who helps the promotion in his professional capacity is not a promoter. But any such person may become a promoter if he helps the formation of the company by doing an act outside the scope of his professional capacity. A person cannot, however, become a promoter merely because he signs the memorandum as a subscriber for one or more shares. In conclusion, it may be said that the word promoter is used in common parlance to denote any individual, syndicate, association, partnership, or a company which takes all the necessary steps to create and mold a company and set it going. Now let's talk about the duties of promoters. The promoters occupy an important position and have wide powers relating to the formation of a company. It is, however, interesting to note that so far as a legal position is concerned, he is neither an agent nor a trustee of the proposed company. But it does not mean that the promoter does not have any legal relationship with the proposed company. The promoters stand in a fiduciary relation to the company they promote and to those persons whom they induce to become shareholders in it. Following are the major duties of the promoter. First, duty to disclose secret profits. A promoter is not forbidden to make profit but to make secret profits. He may make a profit out of promotion with the consent of the company, in the same way as an agent may retain a profit obtained through his agency with his principal's consent. A promoter is allowed to make a profit out of a promotion but with the consent of the company. Second point, duty of disclosure of interest. In addition to his duty for declaration of secret profits, a promoter must disclose to the company any interest he has in a transaction entered into by it. This is so even when a promoter sells property of his own to the company but does not have to account for the profit he makes from the sale because he bought the property before the promotion began. Disclosure must be made in the same way as though the promoter was seeking the company's consent to his returning a profit for which he is accountable. Next point, promoters' duties under the Indian Contract Act. Promoters' duties to the company under the Indian Contract Act have not been dealt with by the courts in any detail. They cannot depend on contract because at the time the promotion begins, the company is not incorporated and so cannot contract with its promoters. It seems therefore that the promoter's duties must be the same as those or a person who acts on behalf of another without a contract of employment, namely to shun from deception and to exercise reasonable skill and care. Thus, where a promoter negligently allows the company to purchase property, including his own, for more than its worth, he is liable to the company for the loss it suffers. Similarly, a promoter who is responsible for making misrepresentations in a prospectus may be held guilty of fraud under Section 17 of the Indian Contract Act and subsequently liable for damages under Section 19 of the Act. Fourth point, termination of promoter's duties. A promoter's duties do not come to an end on the incorporation of the company or even when a board of directors is appointed. They continue until the company has acquired the property or business which it was formed to manage and has raised its initial share capital and the board of directors has taken over the management of the company's affairs from the promoters. When these things have been done, the promoter's fiduciary and contractual duties cease. Remedies available to the company against the promoter for breach of his duties. Since the promoter owes a duty of disclosure to the company, the primary remedy in the event of breach is for the company to bring proceedings for rescission of any contract with him or for the recovery of any secret profits which he has made. Under this, first comes the rescission of contract. So far as the right to rescind is concerned, this must be exercised on normal contractual principles. That is to say, the company must have done nothing to show an intention to ratify the agreement after finding breach involving non-disclosure or misrepresentation. Second, to recover secret profit. If a promoter makes a secret profit or does not disclose any profit made, the company has a remedy against him. So this was about duties of promoters, and now let's start with liabilities of promoter. A promoter is subjected to liabilities under the various provisions of the Companies Act. Section 26 of the Companies Act 2013 lays down matters to be stated in a prospectus. A promoter may be held liable for non-compliance of the provisions of the section. Under Section 34 and 35, a promoter may be held liable for any untrue statement in the prospectus to a person who subscribes for shares or debentures in the faith of such prospectus. However, the liability of the promoter in such a case shall be limited to the original allottee of shares and would not extend to subsequent allottees. According to Section 300, a promoter may be liable to examination like any other director or officer of the company if the court so directs on a liquidator's report alleging fraud in the promotion or formation of the company. A company may proceed against the promoter on action for deceit or breach of duty under Section 340 where the promoter has misapplied or retained any property of the company, or is guilty of misfeasance or breach of trust in relation to the company. The Madras High Court in Prabir Kumar Mishra versus Ramani Ramaswamy had held that to fix liability on a promoter, it is not necessary that he should be either a signatory to the memorandum or articles of association, or a shareholder or a director of the company. Promoters' civil liability to the company and also to third parties remain in respect of his conduct and contract entered into by him during pre-incorporation stage as agent or trustee of the company. Now let's talk about status of pre-incorporation of contracts. The promoter is obligated to bring the company in the legal existence and to ensure its successful running, and in order to accomplish his obligation he may enter into some contract on behalf of prospective company. These types of contracts are called pre-incorporation contract. Nature of pre-incorporation contract is slightly different to ordinary contract. Nature of such contract is bilateral, be it has the features of tripartite contract. In this type of contract, the promoter furnishes the contract with interested person and it would be bilateral contract between them. But the remarkable part of this contract is that this contract has the prospective company who is not a party to the contract. One might question that why is company not liable even if it is a beneficiary to the contract, or one might also question that doesn't the promoter work under principal agent relationship? Answer to these entire questions would be simple. The company does not in legal existence at that time of pre-incorporation of contract, which means the company is not legally bound to perform those contracts. If someone is not in legal existence, then he cannot be a party to a contract. Before the passing of the Specific Relief Act 1963, the position in India regarding pre-incorporation contract was similar to the English common law. This was based on the general rule of contract, where two consenting parties are bound to contract and third party is not connected with the enforcement and liability under the terms of contract. And because company does not come in existence before its incorporation, so the promoter signs contract on behalf of company with third party, and that is why the promoter was solely liable for the pre-incorporation contract. However, the provisions of the Specific Relief Act 1963 makes the pre-incorporation contracts valid. Section 15 Clause H and Section 19 Clause E of the Specific Relief Act of 1963 deviate from the common law principles to some extent. Under Section 15 Clause H of the Specific Relief Act 1963, except as otherwise provided by this chapter, the specific performance of a contract may be obtained by first, any party thereto, or b. the representative in interest or the principal of any party thereto, provided that where the learning, skill, solvency, or any personal quality of such party is a material ingredient in the contract, or where the contract provides that his interest shall not be assigned, his representative in interest or his principal shall not be entitled to specific performance, his part of the contract, or the performance thereof by his representative in interest or his principal has been accepted by the other party. When the promoters of a company have, before its incorporation, entered into a contract for the purposes of the company, and such contract is warranted by the terms of the incorporation of the company. Under Section 19 Clause E of the Specific Relief Act 1963, except as otherwise provided by this chapter, specific performance of a contract may be enforced against the company when the promoters of a company have, before its incorporation, entered into a contract for the purpose of the company, and such contract is warranted by the terms of the incorporation. In the case of Weavers Mills Limited versus Balkis Amal, the Madras High Court extended the scope of this principle through its decision. In this case, promoters had agreed to purchase some properties for and on behalf of the company to be promoted. On incorporation, the company assumed possession and constructed structures upon it. It was held that even in absence of conveyance of property by the promoter in favor of the company after its incorporation, the company's title over the property could not be set aside. Promoters are generally held personally liable for pre-incorporation contract. If a company does not ratify or adopt a pre-incorporation contract under the Specific Relief Act, then the common law principle would be applicable, and the promoter will be liable for such breach of contract. In the case of Kellner versus Baxter, where the promoter in behalf of unformed company accepted an offer of Mr. Kellner to sell wine, subsequently the company failed to pay Mr. Kellner and he brought the action against promoters. Earl CJ found that the principal agent relationship cannot be in existence before incorporation, and if the company cannot take the liability of pre incorporation contract through adoption or ratification because the stranger cannot ratify or adopt the contract and the company was a stranger because it was not in existence at the time of formation of contract. So he held that the promoters are personally liable for the pre-incorporation contract because they are the consenting party to the contract. In the case of Newborn versus Sensolid Great Britain Limited, Court of Appeal interpreted the finding of Kellner versus Baxter in a different way and developed the principle further. In this case, an unformed company entered into a contract. The other contracting party refused to perform its duty. Lord Goddard observed that before the incorporation, the company cannot be in existence, and if it is not in existence, then the contract which the unformed company signed would also be not in existence. So, company cannot bring an action for pre-incorporation contract, and also the promoter cannot bring the suit because they were not the party to contract. This case related some amount of confusion. If the contract was signed by the agent or promoter, then he will be liable personally and he has the right to be sued or be sued. But if a person representing him as director of unformed company enters into the contract, then the contract would be unenforceable. These principles were found applicable in Indian case as well. In the case of Seth Subhagmal Lodha versus Edward Mill Company Limited, the High Court of Rajasthan followed the approach of common law regarding liability of pre-incorporation contract. This case was criticized by A. Ramaiah in Guide to Companies Act. Although under common law promoter is liable for the pre-incorporation contract, but there is some scope where the promoter can shift his liability to company. He can shift to company his liability under the Specific Relief Act 1963, or he can go for novation under contract law. In Howard versus Patent Ivory Manufacturing, the English court accepted the novation of contract. A promoter is personally liable for the pre-incorporation contract because at the time of formation of pre-incorporation contract, the company does not come in existence, so neither the principal agent relationship exists nor the company before the party. Company is not liable for the pre-incorporation contract when it comes in existence, but under the arrangement of Section 15 Clause H and 19 Clause E of the Specific Relief Act 1963, company can take the rights and liabilities of promoter. It is also found that promoter is personally liable for the pre-incorporation contract in American law, English law, and Indian law. So that was all about today's lecture, where we touched upon the topic of promoters of a company. And here we finish the first unit of the company law syllabus. Thanks for watching the lecture, and for more such lectures, do not forget to subscribe to the channel. Thank you.